leather interior he asked for in the agreement. The ship delayed, so delivery was made in maybe February 2011, which is later than what is agreed upon in their letter, and was not satisfied with the condition of the car. Ben decided to repudiate or reject the car, demanding full refund of his money. The question is, can he succeed to repudiate? And you are supposed to advise Ben. In another situation or scenario, the car was brought, but imagine Alfred bought and delivered a Toyota Camry 2008 model instead of the Benz car, claiming that it is newer and more affordable. The question is, can Ben repudiate or reject the Toyota even if Alfred was able to meet all the other specifications, the red, the leather, everything intact? Date of delivery, also no problem about it. Now you have to advise Alfred of any remedy due Ben. Was there a breach of condition or warranty by Alfred? So looking at the two scenarios, we realize that there is a breach in each situation, but different types of breaches. In the first scenario, what was the basic or what was the main root of the contract? I think it was Ben's saloon car. So he brought that, but he breached the color, the venue, the time of delivery. He breached all because he had problems. So in that first scenario, then we can advise Ben that he cannot take an action that will demand repudiation or rejection of the car, because Alfred did not breach a condition, he only breached a warranty, the minor conditions or the minor terms in the contracts. After all, he could only ask for a damage. The car could be sprayed back to the color he wanted. A transportation from another venue, he could ask for damage to pay something. So it's not free. There is a breach anyway, but not a breach of a condition. Therefore, there cannot be any rejection, but you can only ask for payment of damage for the inconvenience and all that. But the second scenario, we can realize that Toyota Camry was brought instead of Mercedes-Benz car. These are two different types of models of cars, and therefore we can say Alfred breached a condition because they were asking for a particular type of car, irrespective of the color. So the color, though, is the same, the letter requested was brought, the time was not violated, but they brought a different car type. Toyota is not the same as Benz car. So he has the right to repudiate if he wish. But he could repudiate and even ask for a damage for the inconvenience. So we want to just look at it. We have different examples we can give to explain this, the differences between a condition and a warranty. Apart from this important aspect of a contract or terms of contract, we also have terms which are expressed or implied. Terms which are expressed or implied. First, let's look at the express terms. This is straightforward. Terms that the parties have intentionally discussed and agreed upon are the express terms. For example, a landowner agrees with building company to pay 10,000 for the construction of a house within 1 year. But the parties may also specifically agree that if the cost of building materials go up, landowner will make a fluctuation payment to reflect the cost of increments. So in this example, the subject matter, completion dates, fluctuation payments have been expressly stated. Price adjustments clause are applicable. So you realize that all that has been negotiated in the contract, agreed upon by the parties, have been expressly provided. We can all read it and have a meaning to it. This is what we mean by the express terms. It can be seen. On the other hand, we have implied or assumed terms. And law may read into contracts what parties are silent about. So it's not everything which is expressed will constitute your contract. Terms may not have been discussed and agreed on, but are implied in many ways. So new terms will be introduced into the contract you have written by law, or by the persons themselves, or by the courts. So first, implied terms can be by the parties themselves. The parties themselves will maybe agree when the court finds that, although not discussed by all parties, if brought to their attention, they would have all agreed to the terms. And that is if they have not discussed price escalation during the construction, the court may imply its existence, as in the case of Frafra versus Boachi, 1976. And the Court of Appeal implied a warranty of fitness, that the tractor to haul timber should be fit for that purpose. So if the condition changes, then there is a problem with that contract, though not expressed. And we have the same under the Sale of Goods Act. The condition or the sale of goods concerning the condition of the goods will also be considered as a condition. So it is implied from that law. Also, it could be implied by statutes. A number of statutes contain implied terms. As I've already said, Sale of Goods Act has it that the delivery of goods by the seller shall be concurrent with payment of those goods by the buyer. Also, the conveyancing decree also implies various covenants for both transferors and transferees. So by way of lease for valuable consideration, there shall be implied the covenants relating to payment of rent, repair of adjoining premises, alteration, illegal or immoral uses, nuisance, annoyance, and yielding up the premises. And these are all implied by statutes. You can find them in various statutes. Even when you are employing, there are a lot of regulations under the Labor Act 2003, which can be implied into your agreement with your employer. So these are not expressed in the contract itself, but can be implied from where? From the statute that is existing. So law can intervene or interfere into a contract you have made with another party, not necessarily relying only on what you have put down as your agreement. So you must expect other laws interfering into whatever contract you have made. For example, if there's an element of crime, then the criminal law will interfere in your agreement. If it's tort, nuisance, or maybe negligence, then another law will interfere, and that will be the laws of torts. So the law of tort will be applied, though you did not really plan or anticipate for such a law to be introduced into your agreement. It could also be implied by custom. The terms of a contract between two parties can be implied by custom. That is when a course of dealing between the parties establish a pattern of consistent arrangement which can be deemed to apply to their continued dealings. If there is a regulation, a customary practice between two parties, how they go about their transaction, then the court, in the absence of any other provision which is expressed, then they will use that customary practice as a means of judging whatever problem arises between the parties. And when the practice, for example, in the industry, is to incorporate various well-known terms in their business transaction, then a customer practice will be applied. For example, in the British Crane Hire Company Limited versus Ipswich Plants Hire, by industrial practice, it was for the hirer to indemnify the owner for damages to equipment under hire. If that is the practice, then in the absence of express provision in the contract, we can use the customary practice between the parties and their dealings. So in the absence of express provision, and also in the absence of any legal provision, then we can rely on whatever practice has existed between the parties, and then they follow that in judging any conflict between the two parties. So customary practice can be used, or customary law can be used to really determine whether the parties have breached or not. And also it could be implied by the courts themselves, as in the case of Akers versus Ghana Museum